This is an appeal in the matter of the claim on the application of UYR and Derby City Council and Bedford Borough and Manchester City Council.
Yes.
I'm pleased, Your Lordship, I appear on behalf of the appellant in this matter, with the respondent represented by Mr. Gardner and Miss Ferrin,
Yes.
and the second interested party being represented by Mr. Hall.
Thank you.
There was just one little piece of housekeeping, which is to include the last few paragraphs of one of the authorities.
Thank you.
And also to hand up the section of the Senior Courts Act, which is the power that the court has to make interim injunctions.
Yes.
And that's what this appeal is all about, an interim mandatory injunction. The claim that this case is all about is the claimant seeking to be accepted as a child. And from the 6th of May 2025, he was accepted as a child by the second interested party, Manchester City Council. And so from that moment on, the claim became academic. The interim relief application that was considered by the Deputy Judge on the 14th of May with her judgment in July 2025, the claimant applied to be treated as a child until determination of the claim. And that was when he was already being treated as a child by Manchester City Council, because Manchester City Council had accepted him as a child.
Well, the claim actually, was it treated as a child in general or treated as a child by Derby?
Well, the claim is to be treated by Derby as a child.
Yeah.
What all applicants in this situation want is to be treated as a child.
I understand that.
Yes.
But the claim, in fact, was targeted at
Yes.
Derby.
Yes, of course. Not at large. Yes. The respondent and the interested parties in resisting the grounds of appeal, there are two grounds of appeal, are talking cross purposes to the appellant.
So who is talking at cross purposes? The two
The
councils?
two, the respondent and the interested
Yeah.
party. And I explain how. In relation to ground two, that is the challenge to the consideration of the balance of convenience when the applicant is already being accommodated as a child. The interested party, Manchester City Council, seeks to uphold the decision for different reasons than were given by the Deputy Judge. Correctly, it has not advanced any arguments in its skeleton to suggest that the working guidance of 2023 applies to this situation. It doesn't. The working guidance applies to situations where there is a dispute. So the main focus of the respondents, it addresses how to manage a situation between local authorities where there is a dispute.
Where they have made inconsistent assessments.
Yes. And the appellant doesn't demur from that explanation. That is all correct. But that is not our situation. In our situation, there was no dispute. So that's why I say there's a lack of alignment in answering the appellant's case.
Sorry, what do you mean there was no dispute?
A dispute arises where a person appears in the second local authority area and they say, well, I don't think you're a child. And then they can do one of two things. They can undertake their own assessment because the person will be saying, I am a child.
Yes.
So they can go through their own if they want to.
Yeah.
Or alternatively, utilising the working guidance, they can say, well, I noticed...
Rely on the
Yes.
assessment that's already been
Exactly.
done.
Exactly. that isn't triggered when P presents to a local authority and says, I'm a child, and they say, yes, you are. We're going to treat you as a child, and we're now going to
I mean,
provide...
there's no dispute between Manchester and the child. Is
Yes.
that what you're talking about? Yes.
Yes.
All right. Thank you.
And that's why, sensibly, Mr. Hoare hasn't relied on that. He's argued a different situation in his different explanation in his respondent skeleton argument. But that's all correct. But it all deals with situations where the second local authority is saying, no, I don't think this person is a child.
The second authority didn't know of the first assessment.
Correct.
At the time it accepted
Correct.
the person as a child. If they subsequently become aware, as they did, that there has been an age assessment in 2 other authorities, concluding the person is an adult, what can they do then?
Yes. And I'll return to this to some extent later on. If at time A, this person has all the hallmarks of a child, and they say, yes, we accept you as that, and then later on, there is some evidence that suggests that they're not a child. They're entitled at that stage to say, we now have a doubt that you are a child. We can't unilaterally say, well, you're not a child, you're an adult. They have ongoing duties under the Children Act to that person. They've decided that person is a child, and there's a legitimate expectation. You can wrap it up in a number of legal principles, but to change and resile from that position, this is what they have to do. They have to undertake their own age assessment, take into consideration any of this new material evidence and what the person is saying about their age, and make a determination. Now, a prior local authority, and in this case, in fact, 2 prior local authorities, having determined that the person is an adult, don't think would fall into that category. It has to be something new. That's just an evaluative judgment that 2 other local authorities have done. But if they find some evidence that comes to hand, but that, say, for example, those 2 local authorities had decided that the person was an adult because he had a passport and it showed that he was 23 or something. It wouldn't be the assessments per se that warrant a consideration of an age assessment, but it would be that evidence. Say, well, that could have a material impact on our decision that he was a child. We're now going to undertake an age assessment.
It could be the assessment. The assessment could provide the evidence. So if the social workers had done a full assessment and set out their reasons, the second local authority could take account of that.
I think it could, yes, but there'll be less weight. I mean, that's an evaluative issue because they've already made their evaluative judgment. They didn't have any doubt that this person is a child. If they had doubt, they would have said, well, we're going to undertake our own age assessment. But they were presented in this particular case from hospital and said, yes, this person is a child. So we'll go off and do that. So they've already made their own evaluative judgment. So it might, but I don't think it would create great weight. But if that assessment said, well, the reason why we say P is an adult is because he's got a passport, then that would be something material that they hadn't considered at the time when they were presented with P. And then in relation to ground 1, which is whether the strong prima facie gateway has to be applied to this type of judicial review, and whether it was in this instance. I'm calling throughout these submissions that test as the gateway because the appeal courts explain that is the first trigger. That hurdle needs to be overcome before you move on to the balance and convenience. And so consequently, it's not looked holistically, but it's looked at discreetly. First, you have to achieve that, the gateway, and then you move to balance and convenience. And again, in relation to the respondents' answers to this appeal, there has been, to use a term from philosophy, a category mistake from the respondent. Again, so a lot of the respondent's citing of authority deals with the situations where you need to consider the best interests of the child. And the appellant does not demur from that at all either. Those are the requirements about treating children in litigation. But that is not this case. Being a child is the subject matter of this litigation. And it cannot be presumed in order to avoid the gateway.
And you say that gateway, if you're talking about category, you're saying that because there are two issues. One is whether the gateway, I suppose, exists at all, and the second is whether, even if it does or might exist in other areas of public law, whether it applies in this particular category, i.e. age assessment.
Yes, exactly. And that is a category of people, a category of litigation where you don't know that the party is or is not a child. That is going to be decided in the litigation. So any presumptions about how to treat children as a way to avoid the gateway doesn't apply. But my lord, I'd slightly refine the summary that you gave. I don't think it is in dispute that the gateway does apply at large, and it has applied at large in relation to mandatory interim relief injunctions since at least 1980. The question is whether it is right for the administrative court to have disapplied it, or some administrative court judges to have disapplied it to this type of litigation. In the context that there's 3 appeal cases that have reinforced the gateway for this type of litigation at large, social welfare litigation. So that is essentially an issue of principle. Should this specific type of judicial review, when the age of the claimant is to be determined, justify what the administrative court has done, or would it today justify this court making a departure from the settled law and set out different rules for this unique type of litigation? The appellant says no. There's nothing special about these types of cases that would warrant such a departure, either by way of principle, statutory, there's no statutory exception, and other areas of social welfare law have applied it when children have been involved. It's said, first of all, by the respondent that, well, actually, the deputy judge did find that there was a strong prima facie case.
We haven't got, it said that when refusing permission to appeal, excuse me, she said that she had found that there was a strong prima facie case. Is that in some document that we haven't seen? Or is it in some document which we have, which I haven't identified? I haven't seen the form, whatever the form is called. There was reference to that in somebody's submissions, I think.
Yes, that's right. That's my understanding. And her refusals are at the core bundle, page 6.1.
Yes. I couldn't see any reasons in that. I just saw refused, ground
Yes.
1 refused, and not any reference to any reasons.
Yes, it might have been in the course of the discussion that
Right. Okay.
that's what we should say. But you're right. It doesn't. There's no determination by her. but it's said by the respondent that, well, if you look at the judgment as a whole, that's what she did. What she did was she found that there was a serious issue to be tried, and nowhere does she make any strong prima facie case determination. Her judgment, and the material part of it, is at 5.5. The core bundle and other indexes are paginated.
I found the pagination. It completely bemused me, but now I understand it.
Yes.
Yes, thank
So
you.
it's
fine. Yeah.
It's almost as if there's virtual tabs between each of these areas. So perhaps I'll refer to it as tab 5, although there is no actual tab, and then page 5 within that
Right,
part.
thank you. Yes, okay. So where do you want to go first?
So it said that the findings, the discussion that she has at paragraph 21 and 25 amount to a finding of a strong prima facie case. All she does there is set out what's happened up in Manchester. And at paragraph 25, talk about things that are relevant to the balance of convenience, namely deteriorating mental health. That doesn't relate to whether, the strength of whether or not someone's an adult or a child. And you can't infer from that she'd made a finding that there was a strong prima facie case at all. Perhaps what you could say in relation to paragraph 21, it shows that there's a strong case the respondent is a child, and that might be true. It's been accepted as a child, but that feeds into the question my Lord Moylan asked me at the first instance: what was the scope of the claim? And the scope of the claim was to get Derby to treat as a child. And so consequently, if another local authority was treating as a child, it can't then be said that there was a strong prima facie case to ask this local authority, Derby, to then start treating as a child, because duties were owed already elsewhere under the Children Act. So I think that's the highest that could be said.
I'm not understanding that. The moment you're on ground 1,
Yes.
and ground 1, it's a question for the court whether the person is a child or not, isn't it? Once it's challenged in JR proceedings,
Yes.
the question becomes one for the court. So the question is there a prima facie or a strong prima facie case that this person is a child?
There's a prior step, which is, of course, that's what the court is tasked with when the court enters into the litigation, when permission is granted, etc. But at the earlier stage, all judicial review is discretionary. You come along and say, I want Avon to treat me as a child. I'm being treated as a child by everyone else. The court would say that there's no utility in having...
So it's your academic point.
Yes.
So it doesn't go to strong prima facie case at all. It's a different point, which is these proceedings are academic and...
Well, I'm sorry, my Lord. What I mean by that is because it's academic, there's not a strong case against Derby.
It's not a strong case for granting any relief.
Yes. Or full stop. Yes, correct. But also not a strong case because it's academic, both. So, I think that's at the highest you could say that.
Can I just explore that a little bit further? Because that's premised on the fact that Manchester has accepted this person as a child.
Yes.
But if Manchester, now we've discovered there's an issue about that,
Yes.
rather than carry out our own age assessment, this is already before the court. We're just going to await the outcome of the court decision.
No, because even if that, whatever happens in relation to Derby in the court proceedings, Manchester can't say that because it is or has accepted as a child.
But if it turns out after these court proceedings that the person is not a child, then surely Manchester has no jurisdiction to treat it as a child, treat them as a child.
No, in fact, you can have incoherent decisions on child, but the more relevant point of that is in relation to this appeal, in relation to mandatory relief. Even if that was the case, Manchester would have to wait until the end of this litigation. It couldn't at this stage.
No, I understand that's a different point, but
Yes.
in terms of whether the proceedings are academic, which is your...
Yes.
Whichever way you put that point, I'm on that point at the moment, is it right to say that they're academic when the outcome of the decision in this case would be determinative across the board of whether this person's a child or not?
Well, that assumes that you don't consider at permission that already some local authority is treating the person as a child. So it's actually a hypothetical situation. It's not what happens in practice. But let's assume that that could be done, that a local authority that was treating a person as a child says, oh, I noticed that you're, for some unknown reason, you're JRing another local authority that you lived in earlier in time. Well, we'll just wait and see what happens in relation to that, and then decide what we're going to do in relation to you and treating you as a child. Yes, that would feed in, that could feed in at that later stage where they say there's now been a material difference. As a result of that, we are no longer going to treat you as a child. But that's very removed from saying, oh, well, Manchester can just sit back and let this litigation go on. This litigation wouldn't go on as a matter of practice because the court would say there's no purpose in this because you've already been treated as a child.
No, that's not an issue before us, is it? Whether the proceedings themselves should go on.
No.
We're only concerned with the interim relief.
Yes. So the deputy judge in this case didn't make that finding, and the respondents say, well, she didn't actually need to, because these types of cases are different.
Yes.
That requires consideration of the authorities.
Yes.
And the first authority that needs to be looked at is DeFalco in the authorities bundle at tab 1, please, page 1.
This isn't a question at this stage, but just so that you're aware, for my part, I need some persuasion of the starting point that you've identified, that there is that general principle. So just as you're going through the authorities, just to be aware, I haven't necessarily got to that point so far.
Yeah, I'm obliged for that indication, because that's the journey I want to go on through DeFalco, Francis, and then BSI to show the entrenchment of this settled approach to mandatory interim relief.
Right. Speaking as someone who sat in the administrative court for many years, made interim orders and saw interim orders made by other judges, I don't have a sense of that being a firmly established principle. So just so you're aware, as you're going through the authorities, I need a bit of help on that.
My lady, yes.
Yes.
DeFalco is at page 1.
Yes.
And it's a decision of the Court of Appeal in relation to social welfare claim.
Yes.
Where they were applying for accommodation. At this stage, housing judicial reviews were still in the administrative court. And as part of that litigation, they asked for accommodation pending resolution. In other words, a mandatory interim relief. And Lord Denning, then Master of the Rolls, deals with this at page 19, please, Lord.
Yes.
At letter C, under the subheading, granting of an interlocutory injunction.
Yes.
This is not the same sort of case as American Cyanamid, because the plaintiffs here cannot give any worthwhile undertakings and damages. Pausing there, And that's often the case in this type of social welfare situation. No injunction should be granted against the council unless the plaintiffs make out a strong prima facie case that the council finding of intentional homelessness is invalid. Lord Denning says he would go further. But that is the gateway. And so, my lady, it may well be the case that in other areas of litigation, perhaps the gateway isn't applied universally, albeit BSI, which is the most recent Court of Appeal authority, says it should be. But at least from DeFalco onwards, it has been the test that is applied in relation to social welfare situations. And then Lord Bridge deals with this in more detail in his judgment, and he summarises the questions that he needed to consider at page 20, please, my lord, at letter F. He says, two important questions of principle arise which have not previously been considered in this court. And the second of those is, in any proceedings where such a decision is challenged, can the court grant interim relief in the form of a mandatory injunction requiring the local authorities to secure accommodation for the applicant's occupation? And if so, on what principles should the court act in deciding whether such relief ought to be granted?
Yes.
And then he answers that question on page 22, please, my lord, at B. In considering what principles should govern the exercise of this discretion, he says there is that inherent power. It's now ossified into the Senior Courts Act, 1981. He sets out the new principles that should apply because he couldn't discern such from earlier case law. And then he says, a dispute between an applicant who claims entitlement to be provided with accommodation and a local authority who dispute that entitlement exhibits sufficiently unusual features to make a comparison even with other types of litigation where a mandatory injunction may be granted on interim applications difficult and possibly misleading. So pausing there, my lady, I think the considered view from BSI is that it does apply generally, but even if it doesn't, DeFalco said it certainly does and gives reasons why the gateway does apply to this type of litigation. And then he says...
I'm not sure DeFalco tells us that, because if you read Lord Justice Bridge there, he's saying this particular type of case is different from all others. So
yes.
It's how that's been interpreted in other cases.
Yes,
no doubt we'll come to.
Yes, and I'll leave that dispute for others to see whether or not BSI is correct, because we fall full square within this little area of litigation. And it says at paragraph F, in light of these considerations, I think the court inevitably must make the best assessment it can on an interim application for a mandatory injunction of the strength of the applicant's claim to impugn the local authority's decision adverse to him, and should only grant relief sought if a strong prima facie case is made out.
The consideration immediately prior to that is the fact that this is in a context of a system of priorities. So if you give this person the relief, that's going to push someone else out of the list or further down the list. That's one of the considerations he takes into account. That's not so here, is it? Because if someone is a child, the authority has an obligation to treat them as a child, irrespective of how many other children are also within the area.
Yes, that's correct. And I think that was actually wrong in this case as well, because under the underlying legislation, which I think at this stage was the Housing Act 1977, there's not a resource question. If my lord is aware of the difference between Part 6 and Part 7, what is now Part 6 and Part 7 accommodation under the Housing Act 1996, if you've got a duty to house, again, it applies the same way as child responsibilities. If you've got a duty to house, it's not a resource question.
So that would suggest that the consideration he relied upon, if it didn't apply, rather undermines his conclusion then. If he's given a bad reason for it. Is that what you're saying? He's given a bad reason?
I'll need to look to see if, because my understanding was this was a priority need case, and so that would fall full square within Part 7. I'll look at that and return to that, my lord, if I can. And importantly, at that stage, what the respondent would be saying is, look, the presumption of legality should apply. If we've made a decision, in that case, it's a decision about housing. Until the court has proved otherwise, no interim relief should bite against us. And that isn't a sufficient answer, because once the litigation has started, the issue is at large, and that's why it's completely right that the strength of the applicant's case needs to be considered. Because if it's a weak case, it's much more likely that the local authority's decision is going to be upheld. If it's a strong case, then it's much more likely at trial that the decision will be modified or quashed. So consequently, if you're going to be requiring specific steps from a local authority, it is completely pertinent whether you've got a strong case or not.
So it may be pertinent, but I wonder why does that lead to this threshold gateway conclusion, as opposed to the strength of the case is one of the factors that's highly relevant in the balancing exercise?
It could have been dealt with in that way, but the appeal courts have said that this is how it needs to be dealt with. First of all, you look at a strong prima facie case, and then you look at other factors in relation to balancing of convenience.
And that we find in other decisions too, you're taking us to, because I don't read that from DeFalco. DeFalco doesn't use the expression gateway threshold. It simply refers, as my lord has said, to the strength of the case as being a relevant factor.
Yes.
And I appreciate that Lord Denning says it in typically quite trenchant terms.
Yes.
But even he doesn't say it's a threshold or gateway.
Yes. But that is the way it's been.
Right, so we need to move on.
Yes.
I'm just looking.
Yes.
Because I think you're going to take us quite a few authorities. Yes. So the next one.
Fortunately, in less detail than that.
Right.
One. It may well be, in practice, that a judge amalgamates those two elements into the final decision, but it needs to, as part of that process, have a finding that there is a strong prima facie.
If it's a gateway, a judge shouldn't be amalgamating them.
If it's a gateway, the judge shouldn't be amalgamating it. That's correct.
So it is an important point.
Yes. So 20 years later.
Yes.
The Francis case, which is at page 27 of the authorities bundle, dealt with the test again.
Yes.
And confirmed that DeFalco should apply, and that a strong prima facie case should apply. And that's at page 32, paragraph 16. Please.
This was housing again.
Yes.
So, sorry, which page?
Page 32, paragraph 16.
So, what's there set out is that a strong prima facie case, that approach was in line with the settled law that a different and higher standard is required for a mandatory rather than a prohibitory injunction.
Yes.
Yes? So you rely on an interim mandatory injunction requiring a local authority to perform their statutory duty would not be granted unless the applicant could show at least a strong prima facie case.
Yes. And then that was considered by the Court of Appeal in the RRR case another 20 years or so later.
Yes.
That's in the bundle at page 261.
So there's no, are you saying there's no reference between 2002-3 and 2024 to DeFalco to which is relevant to our decision?
I haven't found any references.
Just to note, strictly speaking, Francis isn't binding because it's a two-judge court.
Yes.
That's right.
And in any event, it was looking at what was the jurisdiction of the 204s, which had been hived off,
Yeah.
rather than the rules of the administrative court. But the rules under 204 mirror the developments in and apply judicial review principles. And it was saying when you do apply judicial review principles, apply DeFalco.
Sorry, what was saying that?
Francis.
Okay. Are there any subsequent authorities that use the words either threshold or gateway?
I don't know, my lord. I can look that to see if...
I mean, because it just strikes me that we've looked at DeFalco and Francis, and it would be surprising if it was settled law that there was a threshold or gateway, that you haven't been able to find any subsequent decision that sets out that settled position, speaking for myself. And I'm nothing like as familiar with administrative law as my lady is.
my lord, yes. If there is some, I'll endeavour to find it. I haven't looked at that specific issue.
Right. So you're taking us to RRR. Yes. So which bit?
So that is it is at 211, but in internal paragraph.
And this is not housing,
No.
obviously.
It's not housing.
It's
What?
to do with a machine defibrillator.
Yes.
Yep.
And the issue there was, is it safe?
Yep.
And we don't think it's safe, so we're going to cancel your license until you prove that it is safe.
Yes.
And the company said, that's outrageous. We're going to have massive commercial consequences of doing that. And so, at first instance, there was a mandatory injunction stopping that withdrawal of the license. The BSI appealed that to the Court of Appeal, and then the Court of Appeal tackled the issues about a mandatory interim relief injunction. And those are the issues that the court had to grapple with are identified at paragraph 75, please, my lord.
Yes.
Including under Roman 2, what is the court's approach on an application for judicial review to the grant of mandatory injunction requiring a decision maker to make a particular decision?
So which paragraph is that? I'm sorry.
75 2.
25, thank you.
Well, I think it's 1, 2, isn't it? Was the nature? Well, I suppose nature means jurisdiction. Yes. Right.
And I think what's important from this is I don't think it really matters whether it is called a gateway, but you have to find, as part of that process, that to grant interim mandatory relief, that there is a strong prima facie case. You have to make that finding. So whether you do that as an initial step or as part of an overall balance matters not. So perhaps that's my...
I think it does matter, because if it's a gateway, then unless you conclude there's a strong prima facie case, that's the end of it. If it's part of the balance, then you could put the strength of the case into the balance against the consequences. And the consequences may be so extreme that even though it's not a strong prima facie case, you still grant relief. So I think it is quite an important distinction.
Well, that's right, my lady. But I think if it's more the timing of when you consider that, because you have to find it. So you can't go on and say, I don't think there's a strong prima facie case, but I'm going to grant mandatory interim relief anyway. So it doesn't really matter when you do that. It has to be a necessary. So it's perhaps inelegant to call it a gateway. It's a necessary condition of the grant of...
So when you're doing the balancing, if there's no strong prima facie case, whatever the other balancing factors are,
Yes.
you can't grant it.
Correct.
Your argument.
Can we, I don't know where you're going, can we look at paragraph 76
Yes.
of when I think it's addressing the first question, the nature of course jurisdiction. And the judgment refers to the fact that it's not the actual jurisdiction in section 31 of the Senior Courts Act.
Yes.
And then it goes on, it's true that when considering whether or not to grant interim relief in an application for judicial review, the court applies the principles
Yes.
in American cyanamide by analogy.
Yes.
And I think the by analogy comes from another earlier decision. But so there, it's being expressly stated that the court does apply the principles in American cyanamide.
Yes, at large, that's correct.
Yes.
And then when dealing with the mandatory interim relief, as this case shows, you need to satisfy as part of that process that there's a strong prima facie case.
But you see, DeFalco was saying it's not American cyanamide.
I think it's a addition to American cyanamide, that as part of the general approach, you need to find a strong prima facie case.
Yes.
So it's a necessary condition for this
Yes.
type of...
I'm just trying to understand how DeFalco fits, because you're saying that RRR, in a sense, endorses or validates DeFalco. And if I remember it correctly, DeFalco says not the same sort of case as American cyanamide, and I think Lord Bridge, in fact, said you don't apply. The principles have no relevance to the case that we are considering, he said. Whereas here, a more recent expression is that when considering whether or not to grant interim relief, the court applies the principles. And so, and as I understand your submission, you're saying, yes, the court does apply American cyanamide, but with the addition of, as you said in answer to my lady, the court has to find a strong prima facie case, not necessarily as a gateway, in order to justify the grant of an injunction
Yes.
of any type.
Yes. I think it's a very watered down American cyanamide test if it does circulate within the administrative court, because they talk about that and then they say, well, actually, this is a situation which involves public authorities, so we've got to tweak it slightly because of that. And then they say, when dealing with mandatory interim relief, and in addition, you need to provide a strong prima facie case. So I'm unclear as to whether that is just paying lip service to American cyanamide or whether there is anything remaining once the judge gets down to consideration of whether interim relief should be granted in the particular case.
Well, we've then got the medical justice case, which RRR deals with at paragraph 79.
Yes.
And medical justice was explaining how you might apply the principles of American cyanamide in the public law context.
Yes. And it reiterates those arguments again about a presumption of legality or regularity to weigh heavily against the grant. And then under ground 2,
there's mention of gateway in paragraph 79. I'm just trying to see if that's relevant. Yes, so this is in RRR. He clearly distinguished between the gateway to the assessment of the balance of convenience, is there a serious question to be tried, and the issues which are relevant to the assessment of that balance. So isn't that saying this is not a gateway? The gateway is there a serious question to be tried?
Sorry, my lady. Where
paragraph
in
79.
Where in paragraph?
The top of the right-hand page, but the second line.
Yes. I can't remember whether in that case it was applied that there was an issue about mandatory.
Well, if we look at what Mr. Justice Cranston said in the medical justice cases at page 75, I think this is where the Justice Lang is getting it from. He says in paragraph 6, the principles governing the grant of interim relief in judicial review proceedings are those contained in the well-known decision of American cyanamide,
yes,
but modified as appropriate to public law cases.
Yes.
First, the claimant must demonstrate there is a real prospect of succeeding at trial. So that's where I think it's an accurate summary of the earlier decision. And it also deals with another decision. So going back to the paragraph 79.
Yes.
I think my lady was asking you about the gateway there being described as, is there a serious question to be tried? Yes.
Then you can see when they considered paragraph 2 as part of that gateway or part of that balance, what relevance is defalco at paragraph 86 onwards?
Can you remind me what was ground 2?
Ground 2 is how should a court deal with applications for interim mandatory relief?
So the judge was wrong to grant a mandatory injunction.
Yes.
Right.
Yes. So under ground one, and that's where we've just been looking, that just deals with interim relief as a whole. That's correct. And there was discussion about a gateway in relation to interim relief as a whole. But then you go on to ground two, which is a higher situation, which is, well, we're not just asking for interim relief, we're asking for mandatory interim relief. What should be the test in that situation? And it's completely understandable that the court has said, well, there has to be a higher test, because that's a situation where you're requiring the defendant to take actual steps. And it was suggested by the company in that case that you didn't need to show a strong prima facie case before getting interim relief. In other words, they said, oh, DeFalco has been overruled, and the court said no at paragraph 87.
I mean, in your favour, it could be said that paragraph, the way the argument is put about DeFalco is set out at 55, and Lady Justice Lane records reference to DeFalco and then says this is the argument is this is not part of the assessment of the balance of convenience, but is a threshold test.
My lord, yes.
What she then says later on is DeFalco has not been. DeFalco remains good law. I suppose query whether she means all the aspects of it that have been identified in the argument, including that aspect.
Yes. I'm obliged to my lord. It's just a question of going through BSA and finding out the bits where they say it's a threshold. I've called it a gateway, they call it a threshold, my lady.
But in paragraph 87, she then distinguishes
Yes.
age assessment cases.
She does. So what the, as part of their case, the company said, well, there is no universal application of a mandatory injunction, and then they cited some examples of that, i.e. age assessment cases. And that's completely right, my lady, that it hasn't been applied, and the question for this court is that wrong? Was there an entitlement of the administrative court to create this exception out of the approach to mandatory injunctions on social welfare law? We completely accept that is what has happened in practice in the administrative court.
So you obviously this is an appeal against the decision of the deputy judge in this case. No mention is made anywhere of this line of cases in her judgment.
Yes.
But as I understand it, it wasn't argued on this basis, was it, in front of her? Were these cases cited? They weren't in your skeleton below. Were they otherwise cited to her?
No, the cases that in relation to age assessment were before her.
What I mean, these cases, the DeFalco point. Was DeFalco cited to her? Were the cases RRR and the other one?
No, RRR wasn't cited, and I can't remember whether I put DeFalco in my submissions at that stage.
But I think your case below was squarely the court is to assess whether C has raised a serious issue to be tried, and then went on to the balance of convenience. So this point wasn't argued in this way below, I think, was it?
It wasn't fleshed out in the short hearing below. No.
So to be fair to the judge, she
Yes.
she can't be criticised for not having dealt with this.
No, she can't be particularly criticised, but it is, we would say, what she had to apply in any event in this case. That was answered as being applicable in mandatory cases at paragraph 87. And then Lord Justice Snowden confirms that at paragraph 112, please.
Lord Justice Newgate.
Yes.
I'm sorry, it's Lord Justice Newgate. Sorry,
Yes.
sorry.
And that does say a threshold requirement.
It does. Paragraph 111 explains what ground 2 is, and then paragraph 112 says, yes, it's a threshold. It's a threshold requirement. It's not simply a matter of the balance of convenience.
So that is an authority that supports your threshold.
My lord, yes.
Thank you.
And then they say one of the errors that the court made is, in the present case, the judge did not find such a strong prima facie case before making a mandatory order, and with the caveat of different criticism applying to this deputy judge, the same situation applies. So it certainly does apply to this terrain, albeit it hasn't been applied in the administrative case law. Is there any application to other situations? I've shown you cases in relation to housing where it has been applied. And then it has also been applied when there is no dispute at all about the fact that the applicant has children when seeking relief and or mandatory orders under the Children Act, 1989. Age dispute litigation has one aim. It's first to say, I'm a child, but the rationale for doing that is that then duties under the Children Act 1989 come into play. And UYR, which is at page 201, please, my lord, of the authorities bundle,
Yes.
is a situation where the Children Act is already in play. Sometimes certain families are not entitled to receive assistance through housing legislation because of their immigration status. But that doesn't prevent them getting assistance under the Children Act where they have children within the family. So sometimes there are applications made to the administrative court saying, I want you to exercise your duties under Section 17 and Section 20. And as part of that, they seek interim mandatory relief. That's exactly what happened in the UYR case, my lord, at page 202. The judge there was dealing with a situation where the family had 3 children. And so they were asking for assistance under the Children Act. And whilst their case was being determined in the administrative court, they asked for interim relief. And at page 205, paragraph 15, please.
Yes.
Finally, on the law, there is no dispute that an application for mandatory interim relief for the provision of accommodation can only succeed if the claimant can show a strong prima facie case that the defendant's decision is unlawful. See judgment of DeFalco. In addition, in the public law field such as this, it is necessary to consider the public interest when granting and refusing interim relief. If the defendant is required to accommodate the claimant and her family, precious limited funds will be diverted from others in need. Just pausing there. Perhaps that's that issue about priority that my Lord Justice Zacaroli was talking about. That feeds in at the second stage, which is balance of convenience. If we give mandatory relief here, it may be that local authority can't provide elsewhere, but it's not relevant to the prima facie test. And then at paragraph 16, she applies it. In my judgment, the claimant has not established a strong prima facie case. that the defendant's decision is, in this case, are unlawful. In age dispute cases, unlike GWAR, in GWAR there's no issue. There are people within this family makeup who fall squarely within the Children Act 1989. But even then, you have to apply the threshold. In age assessment cases, that is at large, and the President of the Upper Tribunal has given some guidance on this. Once permission is granted in these types of cases, it's a fact-finding issue, and then it is transferred to the Upper Tribunal, which is a specialist tribunal to determine how old someone is. So consequently, in the BG and Perkins case, the president of that tribunal explained the approach you should take to the subject matter of the litigation. At page 257, please, my lord.
Yes.
The facts of the case are not material, but the applicant was suggesting this at paragraph 66. Ms. Weston submitted that the tribunal must take account of the best interests of the child in considering whether to make an order for specific disclosure. It related to social media accounts, I think. We disagree, since that submission assumes what must be established in the proceedings, i.e. the age of the person concerned. We doubt that consideration of Section 55 of the Border Citizens and Immigration Act 2008 would add much, if anything, to the inquiry required by Article 8 of the European Convention of Human Rights in any event.
This was a specific disclosure application in the context of the broader, the wider dispute as to
Yes.
the person or child.
Yes, yes. And so the facts aren't germane at all, but the reason why this is cited is because here is the president of the actual tribunal that deals with these situations that says you can't have a presumption. You can't say, oh, well, we have to import all those cases that are very live to Children Act cases across, because we don't actually know whether this person is an adult or a child. So that can't feed in at an early stage, and it can't be used as a reason to disapply the threshold.
There is a presumption, isn't there, in the period between the question arising whether the person is a child,
Yes.
and there being an assessment by the local authority. There's
Yes.
a presumption there that you treat them as a child, presumably on the same underlying basis that there's the importance of the rights of the child, even though you haven't established it yet.
Yeah, under a different basis, because you're completely right, and I'll explain that. Here, you can't presume that in the litigation because you've already had those steps at an earlier stage. Under the Assistant Directors of Children's Services guidance, which is the age assessment guidance, if someone comes to a local authority and says, I'm a child, you need to treat them as a child until you determine otherwise. So whilst you go through that age assessment process, you can't say, well, we think you're an adult. Our provisional view is you're an adult, so we're not going to accommodate you. There's only at that earlier stage. Then you've made a decision, and in this case there was in fact 2 decisions from local authorities, and then that is being challenged. So you've made a decision that this person is an adult. At that stage, the claimant can't say, oh, as part of this, I have to be treated in the best interest of the child, and those principles come across. Because at that stage, there's a lawful decision. It's subject to challenge, but there's been a decision that you're an adult.
Yes.
And obviously, the President's very alive to that at an earlier stage. My Lord, I need to take you to how this divergence from the orthodoxy occurred in age assessment cases.
Right.
And that was by a Deputy Judge, Deputy Judge Fordham, as he then was, in the BG case. And that's at page 109, please, my Lord. So up until this case, which is 2014, age assessment cases have been dealt with in exactly the same way as every other case.
Yes.
And then mandatory interim relief was asked for, and that was considered by the judge at page 116, paragraph 30. He was also dealing with permission. And at that stage, it said, in paragraph, neither counsel submits that the citation would be appropriate or necessary for me to apply a degree of arguability. Though were it necessary for the case to be more than arguable, that is to say a strong prima facie case, then I would have been satisfied that this did constitute a prima facie case. So first hand he's saying, look, I would have found this as a strong prima facie case here anyway, but he says it doesn't apply. But there's no consideration of defalco or of the general approach at all. Hence, thereafter it's obiter. And he falls into the trap that the President says you shouldn't do at paragraphs 38 and 39. I'll deal with paragraph 39 first and then return to paragraph 38. At the beginning of paragraph 38(9), he says this: in all the circumstances of this case, pausing there, there's absolutely nothing wrong with that. Then the second part, and in the context of the best interest of the child. That's the error. It's sort of almost like the converse. Now there's not a threshold, even though there is a threshold for Children Act cases, see GIWA. What we're going to do is we're going to water it down, and then we're going to assume, although we're not allowed to, that the person is a child, and import all those general principles. That's not correct. What you need to do is you need to consider the strength of the case and the specific circumstances, which is exactly what he did do in paragraph 38. So far as the inapt placement of the claimant with children when she was assessed to be an adult, what I need to evaluate on the balance of convenience is the risk of injustice, in which one of the scenarios is that the claimant is treated as a child in the interim, but ultimately fails on the substantive challenge, but where, on the other hand, the claimant continues to be dealt with as an adult alongside adults and is subsequently vindicated at the substantive hearing and is found to be a child. What he's saying there is, look, there's inherent risks. If you put someone who's a child in with adults, that's quite risky for them. Conversely, if you put someone who's an adult in with children, that's quite risky to the children. But those are general points, and they are forensically neutral, because it is unknown until you look at the strength of the case whether the person in front of you is child or adult. That then opened the gates, and a number of cases have not applied the strong prima facie case in the administrative court, which then culminated in the same judge, full circle, in 2024, summarising those, and that's in a case called KRA and Cheshire East Council at page 285, please, my Lord. where this departure is then promoted to orthodoxy. At page 288, there's a subheading, serious issue to be tried. And the judge has gone through cases that, all just cases in the administrative court in relation to age assessment. And then
Yes.
Paragraph 16 says, there is no higher threshold requiring a strong prima facie case, whether by reference to A, public law principles, or the context of B, interim relief as being mandatory.
And the authorities referred to from paragraph 6 are all age assessment cases,
Yes.
in some of which interim relief of the type we're discussing here had been granted.
Yes, exactly.
Right.
They're all just working examples of what the court has been doing when presented with interim relief applications since BG in Oxfordshire. And so it's completely circular that he said, well, because other people have followed me and disapplied it, therefore, paragraph 16, it doesn't apply, without any principled discussion about whether that was the intention of Parliament. It isn't. There's no statutory exception. Parliament could easily have done that under any of its Immigration Acts or Children Act. It isn't based on any consideration of principles. It isn't based on any consideration of the case law. Most importantly, Nicole.
I'm just concerned that we're looking that we're concerned here with age assessment cases, and on that, no one has identified any appellate authority as to the test to be applied.
That's correct. There
Yeah.
isn't an age assessment case.
So then you're relying on general principles from other public law cases. I'm a little concerned that there's clearly lots of authority about granting interim relief in administrative court cases.
Yes.
I was just quickly looking at the Lady Chief Justice's judgment on the Palestine Action case, because of course that's highly topical at the moment. And what she says there now, I immediately take the point that that may not be a mandatory injunction,
Yes.
but it's pretty significant injunction that was being considered. And she said there, the current approach to the courts in public law cases where it is alleged the decision is unlawful is to consider whether there is a real prospect that the claimant will ultimately succeed. On occasions, the courts have indicated that they may be reluctant to grant interim relief in the absence of a strong prima facie case
Yes.
that the public body was acting unlawfully.
Yes.
It's a relatively short judgment, delivered urgently, but there's clearly a lot of other authority on the test to be applied in public law.
Yes. That's full square with what we're dealing with here, because she says as that second.
Well, she says the courts have
Caveat.
indicated they may be reluctant.
Yes.
That's rather different from a gateway test.
Well, as I say, that I think is in relation to interim relief generally.
It is.
But that's correct. But in the context of mandatory interim relief, the courts have also said this is what you need to do.
Well, very often there's not that much distinction between mandatory and
Yes, that's true.
prohibitory. Sometimes it depends how you word the injunction.
That's true.
Yeah.
Yes. But I think my lady's question is this: look, we've got a special set of cases. Shouldn't they be treated differently? And to some extent, that's reversing the question. The question is,
in the age assessment.
Yes.
No, my question is more fundamental than that. It's actually, is there an established line of authority that shows that generally in public law you have the higher test? I'm
no, there isn't.
troubled by that.
There isn't case law to say generally in public law there's a higher test, but
Right.
there is case law to say the higher test applies when you are forcing a defendant to do something. And that's completely logical. If you are just asking for the status quo, you may be able to just say there's a serious issue to be tried. Let's look at the balance of convenience, which they do, and say, well, yes, okay, it's not going to prejudice anyone too much. Let's keep the status quo. Now, that's fundamentally different from saying, I don't like the status quo. I know that the public authority has made a decision. I don't agree with it. This is what this litigation is all about. But whilst that goes on, I want them to act as if they had made the decision in my favour. And asking a court to do that requires the claimant to show that they've got a strong case. You can't come along without a strong case and force people to do things when they've already made a decision that's counter to your advantage. So it's a completely rational threshold.
Might it not depend on the other factors in the case? Because you see, your submission in answer to my lady previously was that even if there isn't a threshold or a gateway, the court has to find.
Yes.
And can only grant a mandatory injunction. The court has so found.
Yes.
But that's saying that this one factor will overwhelm all the other factors in the case that might point very strongly towards the grant of a mandatory injunction. And that's an unusual exercise, or it's an unusual form for the court to exercise its discretionary powers under Section 31.
With respect, my lord, I don't think that is the case, because there could be a whole panoply of other circumstances when doing the balance of convenience, but it's going to be setting those into two subsets. Things that help the claimant and things that don't help the claimant. And unless the claimant can say, yeah, I've got a strong case, there's no logic to even exploring all those things. Of course, take that aside, it would be very beneficial to the claimant to be treated as a child in this instance, etc., etc. But none of that flows unless they can show that they've got a strong prima facie case.
So the basis of that submission appears to be it's the mandatory nature of the relief sought that makes all the difference. Because you're forcing someone to do something.
Very much so.
But in the law generally, there's been rather a withdrawal from that, hasn't there? Lord Hoffman in the National Jamaica Bank case.
My lord, I don't know whether
that's cited, isn't it? It's one of the cases in the bundle.
I have not seen any watering down. I've seen a confirmation that is the case.
So what is the case?
That you do need a strong prima facie case. And the Court of Appeal looked at this recently, and full argument was before the court. In RRR.
But that's a public law case, and there may be other considerations in the public law arena, for example, that you're trying to interfere with a decision where the decision maker has a wide ambit of within which the decision can be made, and there's a rationality test which doesn't apply here. That's one difference between public law generally and JR in this case, where the decision is for the court, and that's picked up on in some of the authorities.
No, it isn't completely different. It's just another element to this type of case, because there's often still run public law challenges saying you didn't do it in this way.
They can be.
So they run in parallel.
Yeah.
This is a public law case, so it falls full square within those principles.
The reality is context is everything. And there are some public law decisions where the court's got to be really, really cautious about intervening. I mean, on the logic of your argument, you might have a lower bar for something like Palestine action because it's prohibitory rather than mandatory, than for the individual claimant who claims to be he's a child. And you say it's very logical. I'm not sure I can quite see the logic there.
Yes, I mean you have it within your gift to say this departure from orthodoxy is justified because of special circumstances about this type of litigation. But the appellant's position is that there isn't anything that's unique about this litigation in contrast to litigation under the Children Act, where mandatory interim relief is applied for and a strong prima facie case test is applied. And indeed, it's less impressive and less forceful than that litigation because you don't know whether the person's a child or not. What the appellant criticises, that is within your gift, but Parliament hasn't said that these are exceptional, and the appellate court for the last 40 years hasn't said that this is exceptional. There is no age assessment case which says that these need to be treated differently. This was a departure.
This assumes you persuade us that the orthodoxy is as you say, though.
Yes. And you can look at the orthodoxy in one of two ways. You can do it as I mentioned, you can do it as a threshold, or you can say, okay, I'm going to do that as part of the balance of convenience, but you do have to find it. So it is in there. It's a mandatory.
You have to find strong prima facie case, and if you don't, wherever it fits in the exercise, you cannot grant a mandatory injunction.
Correct.
There's only one answer to the exercise by the court of its discretionary powers.
Correct. The correct approach in age assessment cases was dealt with by Lady Justice Lang when she was a puisne judge in the case called K. KA, which is at page 211, please, my lord.
Yes.
This was a case where mandatory interim relief was sought in a age assessment case, and she applied the law correctly at paragraph 45. The case involved timings and aspects like that, but which are not relevant. And it's interesting to note that of the Mr. Justice Fordham's worked examples in the KRA case, he doesn't cite this one. Paragraph 45 says this: I accept Mr. Zacaroli's submissions that the right of access to justice is a second facet. That is, the right to apply to the court for interim relief, to stay a decision of a local authority pending the court's determination over the age dispute. But it is important to emphasise that this is a right, again, to apply in accordance with the relevant court's procedure. So, pausing there, she doesn't say, oh, well, this is a special type of case. You fall outside of the admin court general principles. Those procedures include the approach that the court applies in relation to application of interim relief in the public law case, medical justice, and defalco. Smith and medical justice were decisions on application for injunctions to restrain a public authority, whereas defalco was a decision about the application for a mandatory injunction, where a stricter test applies.
This wasn't a case for interim relief, though, was it, in fact? This was about the policy, the lawfulness of the policy of withdrawing services at the same time as you make the decision. So the interim relief discussion is over, isn't it?
I think that they were originally seeking interim relief, and the judicial review was dismissed.
But this decision, this judgment, is not about interim relief, is it?
No, it's not. It isn't. It goes beyond that. The attraction of this judgment, unlike the other ones, the worked example, is it's following a proper judicial review, where, as you see from this extract at paragraph 45, the judge had considered all the authorities. In contrast, often when presented with interim relief, it's a very short hearing, just like this one in front of the deputy judge, deal with things very, very quickly, make a finding.
I think my point is it wasn't an application for interim relief, therefore there wasn't an issue before the court as to what the test to be applied on an application for interim relief was. But that wasn't an issue to be decided, was it?
That's correct. But what she did deal with there is how should an applicant approach the court, and how does the applicant get the benefits of the court? And as part of that, she said, well, one of the benefits is you can apply for interim relief.
Yes.
And this is what happens.
I'm not sure that you really need this because you have what was then said in RRR.
Yes,
so,
that's right.
Yeah.
But, although I noticed the same judge that...
It is, yeah.
Yeah, and
Consistency.
there's consistency.
Yeah.
And it shows that there's not uniformity. There's incoherence even amongst the decisions of the administrative court when dealing with this. There are the worked examples that Mr. Justice Fordham relies on, but there are others where interim relief is refused. So
It's an impressive list, Mr. Justice Fordham's decision, isn't it?
Yes. Well, it follows the template of his book. Do a proposition, cite lots of case law for the proposition, go on to the next proposition.
Thank you. Yeah. Right.
That deals, my lords and lady, with ground one. Ground one was, she didn't find that a strong prima facie case. She didn't need to do so. She then went on to consider the balance of convenience. She granted permission because there's never been a case where someone is actually being accommodated as a child and yet interim relief is granted against another local authority to accommodate them as a child. How could the balance of convenience be satisfied in that scenario? The way that
if you take it, I mean, what would happen? That someone would say to the individual in this case, you're being moved to Derby. Is that
what would happen if
yeah, what actually would happen? I mean, they might say, I don't want to.
Yes, exactly. My understanding is he's very happy where he is. This particular applicant's very happy where he is with a foster family.
And you probably couldn't force them to move.
No. And if he didn't want to, he'd had very good grounds against Manchester City Council.
For trying to.
Yes.
Because
Exactly.
he's in their area and they have a duty
Yes.
to accommodate him.
Yes. You can get concurrent duties, as you well know, under the
Yes.
Children Act.
Yes.
You can go to school somewhere, you can live somewhere else.
Yes.
Both local authorities got ongoing duties to them.
Yes.
Manchester's got ongoing duties to him because he said they accept he's a child and he lives there as a foster family. If he then says, oh, look, my lawyers have said that there's interim relief granted against Derby, I don't want to go. Well, Manchester can't force him.
Can we just identify what's not an issue here? So there's the judge did a balancing exercise between
Yes.
the risk of injustice if the claimant in this case was forced to live with adults and vice versa. And you don't object to any of that part of the exercise. It's purely your complaint's purely that there's accommodation. This child is already accommodated. This person's already accommodated
Yeah.
within Manchester.
I mean,
the
that's
only
great.
issue.
That's great that she went on and did all that. But it's not completely relevant to this case.
Well, but also you don't challenge her decision on that.
It's completely irrelevant. Why on earth are you comparing risks about being in adult accommodation? That's not what was before the court. She's just looked at it as if it's a standard case, saying, oh, well, what I've got to do is I've got to look at the risk, just like Deputy Judge Fordham did, look at the risk of being in a child with adult accommodation and being an adult in child accommodation. But that doesn't arise.
So in this case, if Manchester wasn't in the picture,
Yes.
there's no objection to the exercise, the balance and convenience in this case, on anything other than the fact that the child's already accommodated in Manchester. That's the only issue
Yes.
we're concerned with.
Yeah.
And we're not all. There was also no question below that there should be interim relief, but it should have been against some other council. You weren't directing your fire, as it were, as at Manchester. There should be an order against them, not against us. That wasn't.
The respondent sought interim relief against others, but we defended it, saying you didn't need interim relief against us because you've already got it elsewhere.
Right. So
that was part of the original application. Now the respondent, it was misguided in relation to Bedford City Council, and Manchester City Council decided not to attend the proceedings. So, I mean, it was at large, for this judge to have said, again, this shows how illogical it would have been, to say, yes, I'm going to order interim relief against Manchester City Council. Of course, she wouldn't have done that because they were already doing that. What they did was they just put in an email saying, I think it's now disputed. Now, that's wrong because of the reasons I mentioned already. They can't rely on the working guidance.
So your submission is that the balancing exercise was really divorced from the facts of this case?
Yes. Completely. She did it in a standard case, as if it's NAS accommodation. Adult accommodation is a National Asylum Support Scheme accommodation. So that was completely irrelevant. And in any event, even if you do that, you've got to find something specifically that's prejudicing. And there was no evidence before her that this claimant was suffering from his current accommodation. He wasn't. It was the exact opposite. He was thriving in his current accommodation.
And so do you submit no evidence of actual prejudice or potential prejudice?
Yes, it has to be actual prejudice. It can't be theoretical prejudice. That just goes back to that forensically neutral discussion, placing and the risks. What you then have to do is say, this person is in adult accommodation and they really are suffering because they're in a room with 3 male adults. They've got trauma because on the way to the UK, they were attacked by adult males, etc. And say, well, this is the problem with this particular applicant in adult accommodation. So that feeds into the very factual relevances that my lady was talking about. But that comes in at the second stage when balancing it all up. So yes, she approached it in the void instead of looked at what was actually the case. Now, her justification for not actually looking at the reality was this. She said, well, it's...
Sorry, you're taking us to a paragraph in
yes.
judgment.
She says this at paragraph 27.
Yes.
And she says also that the accommodation in Manchester is indefinite. It could be pulled back at any time.
Sorry, where's that?
Was paragraph 30, she says it's no guarantee it'll continue, which is the
Yes.
same thing.
Right. Yes.
Paragraph 8 of her judgment, my lord. She correctly identifies that there's accommodation in Manchester.
Yes.
But she goes on to treat it as if it's a standard case because she says, I think this is why she went on to consider it a standard case, because at the end of paragraph 8 she says, Manchester has attended on the hospital and they've decided that the claimant should be accommodated under section 20 of the Children Act 1989 after his discharge from hospital. Pausing there, you only accommodate under section 20 if you accept someone as a child. So that's why they're being accommodated under that. Thereafter, the claimant has been accommodated in foster care arranged by MCC on an interim basis. Well, it might be the particular arrangements are not long-term, but it's not an interim basis that MCC are the local authority responsible for this child. If she thought that was the case, she was wrong.
You were taking us to 27. Is that were you taking us to the bit where she says that MCC are looking to the defendant to potentially assume the care of the claimant?
Yes.
So her decision was basically this is precarious, it's interim, no
Yes.
guarantee, and actually what Manchester are doing is looking to
Offload.
pass
The buck, yes. And she was wrong on all regards because There was an unconditional acceptance, and so the working guidance doesn't apply in this situation, as Manchester have not pursued that element. And she deals with it as if there is a dispute. She goes on to a case called HA, where someone appears in another local authority and is age disputed. You can revert back to authority number one. That's not this case. As she well knew, because she'd already rehearsed the outline in paragraph 8. She continues that error in paragraph 30. In any event, even if all of that was right, which it's not, the balance of convenience in front of her at time A was this person is already being accommodated, he's suffering absolutely no prejudice, and so there's no positive factors to justify interim relief against this local authority. And in fact, it's completely counterproductive to him. It's not in his best interest. And it is completely counterproductive as a matter of public resources, where one local authority is already accommodating.
Just to look at the facts, at the time of the hearing,
Yes.
was the claimant in foster care or was he still in hospital?
In foster care.
Right.
He was in
My Lord-
hospital in September, as I understand it, according to.
My Lord, I can update the court on that. He's now back in foster care.
But he was in hospital.
He was in
September.
hospital at the date of my skeleton argument, which
He'd
is
gone
where
back
your
into
lordship gets to that.
hospital.
He was in hospital for TB during that period, which included the 1st of September. He's now back at school and in foster care in Manchester.
Right.
What about at the time of the hearing before the judge?
I think at the time he might have been in hospital. It's in Mr. Woodley, my instructing solicitor's emails, which are within the call bundle, my lady.
So was he in and out or was he there?
It appears that he has been a little bit to assist.
My lady, it's
Or
at
email.
tab 7.1.
Thank you.
He had been in hospital up until the 6th of May.
Tab 7 of the supplementary bundle. Is it?
Yes, of the supplementary bundle, my lady, yes.
Yeah.
He was in hospital for a period, so up until then, he was in adult accommodation. He goes into hospital,
Yeah.
and then the hospital contact the social
Yeah.
services, and he's discharged from hospital on the 6th of May into their care. And as Lord Justice Zacaroli says, at that stage, they had no knowledge at all of anything that had gone on with any other local authority, and that's at tab 6.1.
But just where do you get the date that he was discharged from hospital? Because paragraph 2 of that email,
Yes.
MCC decided to accommodate the claimant after he was discharged.
Yes.
Does that mean by the time of this email he had been discharged?
Yes.
Or that was a decision that when he's discharged we will accommodate him?
No, he had been discharged, and my understanding he was discharged on the 6th.
And then, perhaps of less significance, but he went back into hospital at some point, so that he was in hospital in September.
Yes, not significant at all. He's been treated as a child, and he's become ill
Yeah.
subsequently, and he's had
Right.
to go to hospital. And at tab 6.1 was the explanation as to how that accommodation arose. So at 6.1 it confirms what we were just saying, he is accommodated. And it was a result of the referral, and at that stage they looked at him And they said, yes, we accept you as a child. We're giving you Section 20 accommodation. So consequently, the judge was very right in granting permission in this unique situation. And I haven't been able to find any situation where a person has got accommodation, is suffering no prejudice at all, and yet mandatory interim relief under the balance of convenience exercise is granted against another local authority. She was wrong to do so.
Thank you.
My lords, those are my submissions in relation to round 2. Are there any?
Thank you very much. Thank you. Yes, Mr. Gardner.
Very well, my lord, my lady. In a matter of timing to begin with, I do look at the time. I won't be done before lunch, I'm afraid, and I wonder if there's an appetite to break early or for me to get started, and we'll see how far we get before we break. It's only 12:15,
Well,
so it'd be an early lunch.
No, I think we'll go on till 1. Thanks very much.
I'm grateful. So in which case, my lord, I turn first then, without having to go into the facts, as the court is aware, and indeed my learned friend has taken you through them, to ground 1.
Yes.
I start a little earlier in the authorities than DeFalco because I would invite the court to first turn its attention to the actual statutory provision that the court will be considering. It's been handed up in paper
It has.
this morning.
Thank you.
My lord, my lady, the provision which I draw the court's attention to is section 31 of the Senior Courts Act
Yes.
of 1981. My lords, my lady, you will see there that it is subparagraph 2 that the court will wish to draw its attention to. So that's a declaration or an injunction can be granted under this subsection, and then below that it sets out.
Sorry, wait a minute. Where are you?
I apologize. It's subsection 2.
Yes.
A declaration may be made or an injunction granted under this subsection in any case where,
Yes.
in an application for judicial review, which of course this is. And then it sets out for A through C
Yes.
some factors the court will wish to take into account.
Yes.
And then below that, having taken into account those factors, which of course include catch all the circumstances of the case, that it would be just and convenient for a declaration or injunction to be granted. So, my lord, I bring the court's attention to that paragraph because it speaks, I think, to the point my lady was making, which is there a hard and fast rule? And an eyebrow may perhaps be raised, because if there is a hard and fast rule to be applied, then of course the statutory test is going to be the starting point. And it would seem there that what we have is a hard and fast rule that it can be a just and convenient application test. So that is to say, it's a wide discretion, I think, is the point I make.
Well, this is concerned more with the end result, the judicial review, the relief.
Well, it is injunction, my lady, yes. But of course, as we've seen in other cases, we apply Section 31 to interim injunctions
Yes.
as well. And so my submission is you can take Section 31 as the other courts have and say that's our starting point. It speaks to the wide discretion the court has when considering whether to grant an injunction or not. If it assists, there's also Section 37 of the Senior Courts Act. I haven't given you that one, but it in like terms speaks to the just and convenient test.
Section 37
of the Senior Courts Act.
What's it dealing with?
Oh, injunctions, my lady, yes. The power of the High Court to make injunctions.
So there's no hard and fast test in section 31, is your point.
Is my point.
But it is well established that there is a hard and fast rule across the board that there has to be a serious issue to be tried before the court goes on to consider other elements.
My lord, I don't go away from that at all.
Yeah,
It is
so that's a judge-made rule, presumably.
correct, my lord. So here's the point I make, that out of statute, the court has wide discretion. Of course, discretion will be guided by precedent, and that is where we get into the case law.
Yes.
I pause to note at this stage as well, only because it came up within conversation with my learned friend and the bench. There was my lord's reference to National Commercial Bank in Jamaica. It's not in the bundle, I'm afraid.
There's a reference to it, I think.
But there are references to it, and if it assists, you can find the quote I think my lord was probably looking for in other authorities. For example, you can find it in paragraph 12 of AS, which appears at page 237 of the authorities bundle. It is a short point. Perhaps I'll allow the court to turn to it very briefly.
Sorry, I just missed the page number.
Page 237 of the authorities bundle. This is paragraph 12 of the judgment in AS.
Yeah.
And that is my Lord's point of the Privy Council through Lord Hoffman, making the point that often trying to distinguish between negative obligation and positive ones can be a barren exercise. And I think that also, if I may, speaks to my lady's point that actually context is incredibly important when deciding what test should be applied and applying the discretion that the court has to making interim injunctions. I start with those 2 points because they are perhaps important to the wider point the court raised with my learned friend in terms of is there even a wider test that comes out of DeFalco, and I see the reason the court raises an eyebrow to it. The respondent would adopt the points made by the court. This is a difficult exercise, this is a highly discretion-based exercise, and it lies entirely with the court when you look at those authorities.
Whatever the precise test is, and whether it's a threshold or a gateway or just part of the discretion, there is no doubt that the courts are reluctant to interfere in the exercise of a public authority's statutory responsibilities. So I suppose if that's the starting point, the question is there less of a reluctance in an age assessment case?
Yes.
Or should there be less of a reluctance?
Well, my lady, the focus of my submission, I think, goes to whether there is this gateway or threshold. We say we raise an eyebrow to there being a gateway or threshold, but certainly not in age assessment cases. Is the point we make in submissions. And my lady, you're right to note that in some authorities they do speak to a strong prima facie case as part of the balance of convenience, and indeed even in some of the age assessment-based authorities. But that's the important distinction my lady made earlier, that then forms part of that exercise, the balance of convenience exercise, rather than it being a gateway or threshold test. And that is to be applied at the discretion of the court, depending on the context and nature of the case. And when I make those points, of course, the context and nature of the case, that indeed harks back to Section 31, which allows the court to take into consideration the nature of the case itself. So, my lord, my lady, the submission of the respondent is, as is unsurprising and is made in my skeleton argument, that the correct approach is that, when applying guidance, is that applying out of the American Cyanamid case appropriately modified by medical justice. I can, if it assists with the pens of the bench, I can provide the authority, the places in the authorities for those submissions. But I may just, as it is an understood test, pass by unless that would assist. In observing the authorities themselves that apply in this particular field, and my learned friend is taking you through DeFalco, I don't, unless the court wishes me to do so, as he has done so, need to take you back through that authority. I can simply, I think, make a couple of additional observations. The first, of course, is that when we are dealing with the DeFalco case, and I should say these are on top of the observations that the court has already made, but when we are dealing with the DeFalco case, we're obviously dealing with a case where the court is considering a public law decision under its supervisory jurisdiction, applying Wensbury principles. And, my lords, my lady, you'll see that when I come to submissions relating to the nature of the exercise which is before the court, that is significant. We say that the DeFalco principles can, to the extent they do, fall squarely within that class of litigation. Examining the Court of Appeal level authorities, it may be of assistance, having considered the points already made by the bench. If we go to the Ofsted case as well, that appears in your supplementary authorities bundle at page 166. Sorry, that is actually me taking you to the paragraph, so I'm asking the court to turn to paragraph 62, which is on page 166.
Sorry, 100. I've got to page 150.
I mean, the supplementary authorities bundle, this is, my lord.
Yes.
I have a page 100. Oh, I apologise. You're talking the beginning of the judgment. Yes.
I am.
I apologise.
am.
Yes. If I may then ask the court to turn down to
Because this was an application for an order prohibiting Ofsted from publishing its report.
correct.
Yes.
My lord, I start then in terms of the points I would wish to bring to the court's attention in paragraph 62.
Sorry, hold on.
That is page 166.
Yes.
And my lord, there you see at the top of that paragraph the confirmation of the American cyanamide test in the public law field. And then towards the bottom of that paragraph, and there are two parts within the bottom of that paragraph which may assist the court. The court there mentions, in appropriate cases, the need to take such measures as are calculated to preserve the status quo. That can be a relevant consideration. And to, I think, perhaps foreshadow my submissions, a relevant point that I would make in submissions is that when you're considering the status quo in an age assessment case, we need to be thinking, and we'll come to the reason why, but it's been touched upon by the court already, that the exercise before the court is to determine the age of the child. So an interim injunction is therefore seeking the local authority to continue treating the putative child as a child, as it would do in line with its obligations before the age assessment was undertaken. So I make that point now, and I will go back to the authority on that.
Sorry, I'm not sure I understand that.
Yeah, my lord, so it goes to, when we talk to status quo, because I make the submission there that the court is obviously thinking in a balance case, the court may be wanting to preserve the status quo. There may be some dispute as to what the status quo is in these type of cases. My submission is, arising out of cases such as Lavender J's judgment in S, which is where we get the point before the age assessment takes place, a local authority is obliged to treat the putative child as a child. Status quo, therefore, ante the impugned decision, is you should continue to do that, and that is what you're inviting the court to do. That's my submission in terms of the interim relief application. So that's why I say, if you're considering the status quo and looking at Ofsted, then actually what you're doing by inviting the court to grant the injunction and continue to treat the putative child as a child, is you are maintaining the status quo. Does that assist, my lady?
I understand what you're saying.
Yeah, I'm grateful. Well, I'll move on then, because I may have to come back to the point anyway, but I'll move on because the important part at the end of that paragraph then is the reference to Christopher Clark J being endorsed by the Court of Appeal here, which notes that, well, these principles, applying the American cyanamide principles, these are guidelines and should not fetter the court's discretion, jurisdiction under Section 37, as they are applying there, as I mentioned earlier, to grant an injunction where it is just to do so. So that is, in my submission, the Court of Appeal, they're reminding us that there's no hard and fast rule. We are applying guidelines when we consider these cases, such as American Sign Language, such as DeFalco. And if I may invite the court then to go down to the next page, which is paragraph 64.
If we look at 63, there's and 64, there are quotations from Factor Tame,
Yes, my lord.
where Lord Gough was dealing with the balance of convenience, and says that refers to American Sign Language. Do we happen to know whether DeFalco was quoted, referred to in that decision?
In Factor Tame, my lord, I'm afraid I don't. I'm sure we can inquire.
Okay, somebody.
Well, that's a particularly important decision in the context of interim relief in public law cases, isn't it?
Yes,
Well known and often cited, but not in our authorities bundle.
No, you're right, my lady. Indeed, it's of course House of Lords authority.
Well, and what you're taking us to in paragraph 64 of Ofsted is, I think it was my lady who was saying, there must be a lot of authorities dealing with the general principle or the general approach the court takes to the grant of interim relief, including injunctions in respect of public law cases, of which this is one. Right, okay.
Yes, my lord. I think that must be right. And then I simply seek to draw that 63, 64 to the court's attention, because it is obviously the Court of Appeal relying on the comments made in Factor Tame and Lord Gough, and in particular the point there, again, these cases are to be considered as part of the discretion conferred upon the court, and they don't fetter. There is no particular rule. They are guidelines for the court to apply in any particular case. And to come full circle to the point on prima facie case, if I ask the court to turn now down to paragraph 66.
Well, Lord Gough says there is not fettered by a rule, and generally that that he does. There's any rule that in cases such as these, where a party is challenging the validity of a law, that you have to show a strong prima facie case.
That's correct, my lord. Yes, and then that is then repeated at paragraph 66 in Ofsted.
And in Belize.
Yes, my lord.
Again, repeated by Lord Walker, the court has a wide discretion to take a course which seems most likely to produce a just result.
Correct, my lord. So my lord, I draw the court's attentions to those authorities because they are, I say, useful guideline principles that the court can take into account in coming to its decision in this case. It is the raising of the eyebrow to the gateway test, I suppose. It's perhaps apt that I then move to the more...
I suppose in the Ofsted case, the Master of the Rolls was taking the opportunity to draw together and clarify the law. So it's probably a good starting point, at least, to look at the relevant authorities.
Yes. My lady, so I've been passed a note, which is, I think, very helpful, is that apparently DeFalco was cited in Factor Tame, so it appears that was taken into account.
Well, I need to clarify that. Whilst Mr. Gardner was dealing with the court, I thought I'd better look up the appeal case report. And if you remember from Factor Tame, it went backwards and forwards to Europe, and DeFalco is cited in the rapporteur and opinion of the Advocate General, but it doesn't appear as though it was cited in front of the House of Lords and isn't referenced in any of their speeches. We can provide the AC court case to you.
And that's I draw the court's attention to those authorities simply because they appear to me high authority on the general approach in public law cases. And I know there's a particular point of importance for the court, having considered the discussions with my learned friend earlier. If I may then...
And paragraph 66 sets out the point that's then picked up by the Lady Chief Justice in the case that I read out.
Correct, my lady. So, my lady, if I, my lords, if I then take the court to the principal authority, which my learned friend relies upon, which is RRR and BSI, I know my learned friend has taken you through some of this already. It may be important if I just report back to some particular points
Yes.
within that judgment. If I may start, I'm afraid there are no, in my copy at least, there are no page numbers at the bottom, I'm afraid, but it's authority number 15.
Yes.
And
Sorry, this is the cases.
this is RRR
Oh yes.
in the main authorities bundle.
Yes.
That is authority number 15, which in my PDF, if you're with the PDF, is 262.
Thank you.
And then important, I think, to start with what the court was actually considering, and that is set out at paragraph 2 of the judgment. I know my learned friend addressed you and made the point that the application was to restrain BSI from withdrawing or suspending a certificate, and that goes to his point, I suppose, about it being a prohibitory, about some prohibitory injunctions. It actually goes a little further than that, quite a lot further. If you look to the second point of the decision,
Yes.
what was actually being applied for was requiring BSI, when the certificate expires on the 26th of May 2024, to extend or renew the certificate until determination of the application for judicial review. I say that's important because that is, applying our test of context, that is an incredibly difficult submission to make because they're essentially inviting the court to make an injunction requiring a decision to be made in a particular way before the decision has been made. And that is observed later in the authority, if I may take the court to that in a moment. But I make the point this is an extreme circumstance and not one that comes across the bench of the administrative court every day in terms of application for interim injunctions. Lord, if I then, and I think the court has already to some extent been to it, I think it's important to go back and remind, because it's an important part of my case. If I go then to paragraph 87 of the judgment.
87.
87.
Yes.
I'm just catching up with the court. And my lord, this is the court dealing with the point whether de facto remains good law, and it has already been observed by the court. Within the key authority that my learned friend relies upon to make the point that in age assessment cases de facto should still apply, within the judgment itself, age assessment cases are put into a different category. They are distinguished within the judgment itself, is my submission. So you can see there at the bottom of paragraph 87, one of the first instance decisions which concerned a dispute about age assessment is not relevant. As such disputes are rare examples of disputes in the administrative court or the appellate tribunal that makes a factual decision on an application for judicial review. As a result of the test for granting permission, I don't need to read the entire thing. I simply make the point, well, this was obviously a point made to the Court of Appeal when considering whether de facto should apply in this particular case, and the Court of Appeal said, well, age assessments are a completely different animal. You can't take the judgments from those cases and ask us to consider this case.
Sorry, can I just again? This was. At what stage? So there was a rolled up hearing of the application for permission. Did it deal with the application for judicial review at all, or was that not part of the...
Within RRR, my lord?
Yes.
Yes, I believe it's a substantive judgment, effectively.
No, okay, outcome. Yep, got it, thank you. So 87 is dealing with what? Because the passage, the sentence you took us to, which is the test for granting permission to apply for judicial review, is different.
The point there, and that comes back to I think the KRA point, which my learned friend went to earlier. Clearly, DeFalco has no application to a permission-based test. I don't think that's being argued in this case or at all. What is happening in my submission here is that the court has been presented with a number of authorities from the administrative court in which DeFalco is expressly not applied, which we can go to later, my learned friend touched upon. And the Court of Appeal has, in my submission, firmly said, well, those authorities where DeFalco is not applied are all age assessment cases. Age assessment cases are a completely different type of case. And so they don't assist the court in making its decision here about the implications of DeFalco. So this is me, my lord, moving on from my point of, I suppose, raising an eyebrow as to whether it can be said that there is a gateway at all. This is me moving on to say, well, even if the court were inclined to say there was a gateway, you have the Court of Appeal, the only authority saying that there is a gateway, specifically saying, well, in an age assessment case, it wouldn't be appropriate to use a gateway. And, my lord, it may assist if I also ask the court, it goes to another point I was making earlier, to go down to paragraph 89.
Yes.
And this is the overall question that Lady Justice Lang was answering. Did Judge Aaron making a mandatory order? And the answer, and there was a curious, I suppose, start. Neither counsel could think of a case in which a court has, without deciding whether or not a public authority has acted unlawfully in relation to a decision which is challenged in existing proceedings, required a public authority to exercise a power on a future occasion in a particular way. Now, my lord, this goes back to the point I was making when you need to focus in my submission on the nature of the decision that is before the court that they were dealing with in RRR. It is an extreme scenario where the court is being asked to require the public body to make a decision in a particular way that it is not already made. And one can see that it would be a highly unusual submission for either counsel to say they cannot think of any cases where interim mandatory orders have been made, when we all know that those orders are made all of the time in the administrative court, and they are made, and there are a number of judgments that make them. So, my lord, my lady, this goes back to the, I suppose, overarching point that the context is incredibly important when considering what the test should be. And in this particular case of RRR, my submission is you had a particular extreme scenario. Neither counsel nor the court could think of a case where the court had been asked to exercise its discretion in such a way before. It speaks to quite how unusual this particular case was. That, I say, should give this court some pause for thought to consider whether actually RRR does make out any particular gateway test. Or at least for a general application, because there are well-known authorities, and a number of them, which set out the American Cyanamide medical justice test in public law cases. In terms of the discussion of the I suppose, the key authorities on...
Just, I mean, the other paragraph that deals with it is in Berkeley's paragraph 112,
Yes, ma'am.
where Lord Justice Nugent says that he agrees that DeFalco requires a strong prima facie case. And you would say, well, maybe in that context, but you would submit that that word should be used, or it doesn't really apply generally, because that would be inconsistent with other authorities.
Yes, my lord. I suppose there's two stages to my submission. The first is exactly that. When we apply our discretion and we know that context is absolutely key to what kind of test the court will apply, yes, there should be an eyebrow raised as to whether outside of these extreme scenarios such a gateway threshold should be applied. But even if I am wrong in that submission, you have clear guidance from the Court of Appeal, I say, in this particular authority. It says, well, in age assessment cases, it doesn't apply. And as far as I can see anyway, Lord Justice Newgee does not deal with the age assessment point. That only comes out of Lady Justice Lang's judgment.
Yes, thank you.
Grateful, my lord. It may assist the court, and I was planning at this point to turn then to rather than look at the direct tests on interim relief, which I think the court has a good deal of authority on now, is to expand a little bit about why the respondent says, well, you need to treat these types of cases, judicial reviews in age assessment cases, as a different type of judicial review. That goes back, of course, taking it all the way back to the nature of the case from section 31. I say that because it's also then relied upon in some of the lower court judgments that age assessments are a different type of case, and that feeds into the test that should then apply when considering whether to make an interim injunction. The start of that comes from the well-known authority in and London Borough of Croydon. If it assists the court, I'm now at paragraph 17 of my skeleton. And there I set out the well-known authority, and there you have then Lady Hale in particular, her discussion of the age assessment principles. If it assists the court, Lady Hale's discussion starts at paragraphs, well, the relevant part is paragraphs 26 and 27, and that appears in the authorities bundle at page 48. That's the main authorities bundle.
Yes.
I don't think it's a controversial point, but it is there for a court to see clearly. The question is whether a person is a child. It's a different kind of question. You can see that at the top of 27. There is a right or wrong answer. And above that, at paragraph 26, we know the difference between these type of cases and other types of cases where the court is exercising its supervisory jurisdiction.
Yes.
And if I then briefly ask the court to turn down to paragraph 46.
Yes.
And that is Lady Hale summarising her conclusion. The result being that if there's a live issue about the age of a person seeking accommodation under section 20, then the court will have to determine where the truth lies on the evidence available.
Mr. Paget's point, I think, on one of his points on this was that may be right, but you could also challenge a local authority's age assessment decision on traditional judicial review grounds, that it was reached unlawfully, for example, if you give the opportunity to the person to meet the intentions.
That is right, my lord. There's authority, I think, in both SB and HAM that suggests as much. The practice, of course, always goes back to that first question of, well, and there are a number of authorities that suggest that actually that often now gets rolled up into the question of whether the putative child is a child or not. And so the practice, and I've not come across a case where it hasn't been happened in a long time, the practice now is that once permission is granted, the entire case goes off to the upper tribunal to determine that jurisdictional question. The standard judicial review principles, fairness, procedural fairness of the age assessment and the like, go with it. And so it's determined in the round, it tends to be.
What's the point in the public law challenge if the court is going to determine the child's age anyway, the person's age anyway?
Yes, well, I think that is a source of constant debate within the administrative court and the upper tribunal. There will be some, and I think it's probably still left unopened, is my reading of the authorities, but there will be some who will say this has its own important part, and that does come out of judgments like HAM, But then Ham goes on to say, well, even if there is going to be a finding of unlawfulness, which the upper tribunal can do, there's still that overarching question of what is the putative age of the child. So it's following Ham, really, that these cases will go off to the upper tribunal in any event.
I'm not sure they do always. Quite often at the interim stage, there are compromises, aren't there, where the authority agree to reassess.
Of course.
And of course that might be a shorter process and therefore of interest to the claimant.
Yes. Oh, of course. That must be right, my lady. It's simply, I suppose, if there is a question to be determined.
If the dispute remains, it goes to the upper tribunal.
Correct. And I suppose returning to where I was, if I may, coming from A in the London Borough of Croydon, I should say, just for the pen, I don't ask the court to turn to it, but Lord Hope does make similar points within the judgment. That's paragraphs 51 and 52. It doesn't, in my submission, add, it just assists the court. An additional point that may be of assistance when considering the context in which these claims come before the court is arises out of the case of CJ. That's not in the bundle, but I think it's a well-known point, and I can take the court to authority where it's mentioned. That is simply this, that when the court is determining, or the upper tribunal, I suppose more readily, when the court is, or upper tribunal are determining the age of the putative child, it's not the case that there is any particular burden on the putative child or on the local authority. It's an unusual set of circumstances where the courts have determined that the tribunal will take an inquisitorial approach. So there's no burden on either party, and that, of course, is in stark contrast to the normal judicial reviews where the burden is on the claimant to establish any unlawfulness. So I make that point simply, again, to note that when age assessment cases come before the court at the interim relief or permission stage, or the upper tribunal at the substantive stage, we are dealing with a very different type of case. And my lords, my lady, you'll see when we come to the first instance authorities, and I say that the court should be following those first instance authorities, but that is a particular feature of on why the courts don't apply the DeFalco test in an age assessment case. So in my submission, that is an important feature, and that alone makes out the point that actually the DeFalco test shouldn't apply in age assessment cases. That is, applying the carve-out that RRR allows at paragraph 87, but also looking at the very different nature and the context that arises out of A and Croydon and CJ and Cardiff.
And what's your submission precisely as to why that makes a difference? Why does it matter that the test is a different one?
Well, because you're approaching the context, and in a particular case, if you are applying a strong prima facie case threshold to a case where actually the claimant has nothing to prove, you're applying too high a threshold. Is going to be my submission. There is a particular right or wrong answer, and that is what the Supreme Court says in A. And so I say that is because you have to apply the context and the nature of the proceedings. The nature of the proceedings comes out of Section 31 itself. You take that guidance, and you say these are a different type of case. And so we need
usually in judicial review, the decision is for the local authority.
Yes.
And the judge might disagree with the decision, but there's no basis for overturning it. In this situation, if the judge disagrees, it's the judge's decision that counts.
Correct, my lady. Yes. So it is, because it's a different type of case, there are different standards that apply, and so the application of this of a strict gateway threshold wouldn't be appropriate when you consider the background, that being the application of this different type of case.
Because, as my lady says, the court is not interfering with a power that has been given to local authorities.
Correct. So it's effectively, once it's within the domain of the court and the upper tribunal, it is for the court or the upper tribunal to make that decision as to whether the putative child is a child or not. And that is the difference. My lords, my lady, I say that is an important factor. perhaps the important factor, because it entirely distinguishes it from cases like DeFalco, where we are applying the supervisory jurisdiction, as I say, noted in RRR, that they are a different type of case. I also say, and make the submission in my skeleton argument, that is informed by two other areas. That's the UK's treaty-based and statutory obligations. That is one point, and that is my Article 3 UNCRC point, which I can develop in a moment, but also based on the policy background, that is Lavender J's judgment in S arising out of the policies. All of these judgments, so I should say, all of these principles lead to, in my submission, a legal framework that suggests that what we have is, and I use carefully the words of now Mr. Justice Fordham in BG, a protective and precautionary approach that comes when we are dealing with putative children. I say that also informs the background to why there is a different, why there isn't a different test, a different higher test in these type of cases. So, again, if it assists the court, I'm at paragraph 18 of my skeleton argument. That starts with the general position arising out of Article 3 of the United Nations Convention on the Rights of the Child.
Which is not directly applicable.
Is not directly applicable, that's correct, my lord. And I'll take the court to authority that says how the court may use that, because it's not directly applicable, and that is well known, but it is an interpretive aid, is the key aspect. And I don't seek to ask the court to go any further than look at paragraphs 18 and 19 for the of my skeleton for the general principles. That is Article 3, best interests of children being a primary consideration. And I pause to note there, in all actions concerning children, and that includes in courts of law. And then at paragraph 19, the observations of Lady Hale in ZH Tanzania. At paragraph 23, if it assists, that is in the supplementary authorities bundle at page 70, but the quote I seek to rely on is copied there, so I don't seek to ask the court to actually turn to that. That is simply to note the nature of the obligation on the local authorities in particular, arising out of section 11, and public bodies to carry out their functions have need to regard to the need to safeguard and promote the welfare of children. I say those are overarching principles, and we then turn, if I may, in more detail to how those assist the court in determining whether any higher test should be applied. And here we have the case of SG and Secretary of State for Work and Pensions. The three principles that I suggest arise out of SG are set out at paragraph 20. They are A, B, and C. Those
Paragraph 20 of your skeleton still.
yes, indeed, my lady. I set them out there in those terms. I should say and give due credit. Those are with the addition of bullet points.
So are you saying these? We're trying to work out where these fit in, because this is dealing with the submission that in one way or another the court can only grant a mandatory injunction if the court finds that there is a strong prima facie case.
Yes.
So how do these fit in with that?
Because my submission, my lord, is that when you look to the interpretive principle, so we are dealing with putative children, and so applying the UNCRC, and like I say, we can go to SG in a moment, when we are looking at how we should be interpreting any particular provisions, if we're dealing with children, we have this obligation to treat their best interests as a primary consideration. So I say this is effectively an additional factor that the court can look to say the DeFalco principle shouldn't apply.
I see.
You're going to have to address the circularity problem then, that we're not dealing with children unless and until we are dealing.
Indeed, my lord, and that to an extent I think is made out when we come to the third point, which is the Lavender J judgment and in S and the policy framework. But I make this point because here we are dealing with obviously international treaties that then have not direct effect, as my lord observes, but are aids to interpretation. And so I make the point, I say, that ABC are the principles that the court can take from SG in my submission. They are, I should say, directly taken from Mr. Justice Saini's judgment in MK, in particular at paragraph 32. But to go to the direct point, if I may ask the court to turn to SG, and in particular, if I may start with Lord Carnwath's.
Where is it?
It's at paragraph 101, and that is in the authorities bundle 154, page 154.
Sorry, can you give me the page again?
154, my lord.
Thank you. Yes.
Right at the bottom of the page, you have paragraph 101. And that is Lord Carnwath noting that the possible relevance of Article 3.1 of the UNCRC, and then relying on the Court of Appeal's observation that notwithstanding the fact that the UNCC is an international convention which has not been incorporated into our domestic law, the court should nevertheless have regard to it as a matter of convention jurisprudence. That convention, I should say, is referring to the European Convention on Human Rights. That was a point not challenged by the Secretary of State on appeal. And if I ask the court then to turn down to the next page, which was 105. You see then Lord Carnwath referring to the general comments from the United Nations Committee on the Rights of the Child, which he then sets out 106, the best interest principles, and that being the threefold concept: substantive rights, fundamental interpretive legal principles, and a rule of procedure.
Yes.
And then if I ask the court just to turn over the page to, and then A, Lord Carnwath notes that where a decision will have a major impact on children, a greater level of protection and detailed procedures to consider their best interests are appropriate. And that the child's interests have a high priority, and not one of several considerations. Larger weight must be attached to what serves the child best. And now if I ask the court to turn down to paragraph 115, page 159. And this goes to my Lord's point. It's of course trite law that in this country at least an international treaty has no direct effect unless until incorporated, but it may be taken into account as an aid to interpretation in cases of ambiguity. And whilst I don't seek to go over every judgment of all of the justices within this case, if I may just then briefly ask the court to go down to page paragraph 137, which is Lord Hughes. Which, if I may, makes the point even more clearly. Partway through that paragraph, you see first, the construction of legislation is in doubt. The court may conclude that it should be construed, if otherwise possible, on a footing to honour the international obligations. And then second, international treaty obligations may guide the development of common law. That's an important point as well. And then thirdly, the UNCRC may be relevant to English law in the context of the European Convention. So it's the same point, if I may, my lord, but perhaps a little clearer.
Right. Is that a convenient moment?
Yes, my lord. I think that helpfully takes me to the end of the points on the United Nations Convention on the Rights of the Child. There is a slight overlap when it and it may well be I just simply mentioned briefly before the court retires, paragraph 21, which is the case of Darbo. Paragraph 21 of my skeleton, I should say.
Yes.
And I mentioned it only briefly because unless the court wishes me to do so, and we could do this after lunch if I want to, that brings in the point. Well, you're also dealing with Article 8 considerations when you're dealing with putative children, because as it says there, the presumption of minor age is one which the European Court of Human Rights has deemed to be an inherent element of the protection of the right of respect to private life. So, my lord, that rounds off my point, I suppose, on the UNCRC point, which is you can use this as an interpretive aid, both in terms of the legislation, we're talking about Section 31 and how to interpret that, and you can use it in terms of, there is an Article 8 point here, obviously in relation to the right of the child, and you can use that. And so the best interest of children should be primary consideration. My lord, that being a convenient point, I will stop there with the court's leave, and we can pick up, I think, to the point of S and Croydon after lunch.
Thank you. How much longer do you think you'll be?
My lord, if the court would indulge me, I'm most of the way through my ground one submissions. I suspect if I could have another hour, I'd be very grateful for it.
Yes, if you could make it a little bit shorter.
I will do my best.
Thank you.
Court rises.